Stephanie, I'd like to turn it over to you then, and have you pick up where you left off in talking about the memo.
Great, thank you, Professor Francis. It's nice to be here today. I'm Stephanie Duryea with CSG Justice Center. I think where we left off last time, if memory serves me correctly, is that we had moved through the framework suggestion, which really just poses or provides, I should say, the subcommittee with kind of a structure to consider for where you'd like to see recommendations made. So around controlling case, financial obligations, conditions, sanctions, termination, and the role of parole. With some additional questions there at the end, especially around information sharing and things like that. I think where the subcommittee left off is that we had decided to move through those sections and to determine if there were recommendations to be made around each of those sections. As everyone's really well aware, it is October 14th. Is that correct? I've lost 13th, apologies. It's October 13th, and any report that the subcommittee is going to provide is due November 1st. And so in thinking about the role or the topics for today, I really think it might be important to actually change towards discussing what recommendations the subcommittee might like to see. I know that Shelley and Spence, that you both had some comments last time. Shelley, I filled you in and you had some comments and things like that. But really decide on where you guys think that there should be recommendations made, and then start moving through some of those. So is there recommendations that we can make around information sharing? Are there recommendations that we can make that would help solidify an MOU process? I know that in some jurisdictions, dual supervision is handled through an informal process of just, an ask and an acceptance. So can we improve that a bit? So, where do you guys find, when looking at this framework, areas where we would be able to make or create better consistency across the state? And I'll pause there and kind of open that up for folks.
Yeah, so with respect to information sharing, I think this is where feedback from Spence and Shelley and Secretary Zamuda will really be helpful in them talking about, just from an administrative or mechanical approach, how will this work out? And I think Sheriff Carr also has important insight on this too. So I really like each of you to go ahead and chime in on what should we be recommending that would help address the issue that was laid out last time, which was, information sharing. Sometimes it's great, but there are other times when it's really not so good. Times when it seems to work out better is when the different agencies are in the same building. But what would help facilitate better information sharing if they're in different buildings, if they're across towns, or even in different towns? So I'd like to toss that open to folks to talk about that.
This is Sheriff Carr. I guess to follow up with that, I think to identify the means of that communication, I guess via software or what platforms, because I'm this is Spence and Shelley and Jeff, but not knowing what programs each one of them are using, and so is there a standard platform that they can use in sharing data or information, I guess, to start with?
That's a great point. I mean, I guess the starting point is there a common platform that they all have? And if not, can there be?
Mr. Chairman, this is Jeff Zamuda with KDOC. So I think on our last call, it might have been the one before, but I think it was on our last meeting, the issue came up about information sharing between, I think community corrections and KDOC use the same format. You guys are in our system, aren't you, Shelley? Right? And then I think, Spence, you guys are using, is it Odyssey?
Eventually, it'll be Odyssey. We're rolling it out district by district.
So is there a way for us to create just even a limited portal for information sharing? And if we were going to transfer cases, to utilize that, is it worth that effort? I mean, I'm not, my IT skills are pretty limited, but I do have some pretty sharp IT folks, and I know it's been an issue not being able to exchange information. And I'm not talking about maybe the whole picture. That might be too big to swallow. But would there be any interest from OJA and maybe creating a portal of our information, and then that gets community corrections in, that gets us in, and we get you guys in on at least when we're talking about transferring, and maybe some other limited stuff.
I have just a question to clarify what Spence had said. Spence, when you're talking about Odyssey and you said everybody's going to be on that, do you mean everybody in court services or all the agencies?
Right. Right. And I should have clarified that a little bit better. So all district courts in Kansas will be using Odyssey, which will be the case management system that district courts will use. Court services specifically, though, will be using a product called Tyler Supervision, which is kind of its own entity, but we are integrating that with Odyssey so that court services can see the court information as well. So that's just a little bit of clarification. That's being rolled out statewide, and that we're looking at another 2-year process for that to be completed statewide.
What was it that you said
that
court
will
services
be coming.
was going to use? I'm sorry. Just what was the one that court services is going to use?
We will be using Tyler Supervision. So so the difference is we're rolling that out currently, and correct me if I'm wrong, Shelley and Jeff, but Athena is the system that DOC is using.
Right.
And I believe that has been rolled out statewide, and that's what they're currently using.
So there will be an interface, correct?
Not at this point. No, there's no interface that will happen.
Okay.
That I know, we've talked in some of the other committees as well about trying to make that work a little bit better, but those are still ongoing discussions.
This is Shelley with Community Corrections in Manhattan, and I'm just wondering, and I think I see Hope Cooper on here, through the Community Corrections and Parole and KDOC Athena case management database, we're able to, through a link, we're going to be able to get to other web-based websites, if you will. So like, for example, our risk needs assessment database and the carry guides 4-to-1. And so it'll look like it's within Athena, but it will actually take us out on the web. And I don't understand that either, but I'm just wondering if there is some type of web-based system that just had the basic case information between the judicial branch and corrections, being all of 3 entities. If there was, a case to be transferred back and forth, there's got to be smart data people that can do that if they can allow us to interface with other web-based databases through Athena. And Hope, you might know more information than that.
This is Hope Cooper with KDOC. Can you guys hear me okay?
Yep.
Okay.
Yep.
So our system, Athena, is absolutely set up to be able to do that. We call them, I don't know what this means, but we call them APIs. So we would be able to connect. It's just simply like the secretary was asking, if there's interest, it would take agreements between OJA and KDOC. But the system itself we could easily, I say easily, from a technology standpoint, we could build that in it.
And for me, back to Sheriff Carr's suggestion, I think that would be the best vehicle, would be just sharing of the information if we can.
Yeah,
let me ask, what kind of information are we talking about sharing? What specifically do we want to share? I mean, are we talking about just the case information? Are we talking about if there's violations? I mean, what, you know,
so
because as I think about this, if it's, oh, I'm sorry, Stephanie, if it's violations, you know, I honestly think just an email is the quickest way to do it, right? Because that's instantaneous. You meet with somebody, you send that person an email that says, hey, John just, you know, tested positive for marijuana or meth or whatnot, versus going into the system and doing it that way. But that's just my initial thoughts on it.
yeah,
Just
so this is Stephanie with CSG. Just really quickly. So part of the problem that we were seeing when we were conducting focus groups is that information sharing and the lack of it goes far beyond just violations. There's no information sharing concerning any programming that was completed, any violations received, any incentives that were given. There's not basic case information, a discharge plan. And we heard it in multiple districts that this was a problem. And I don't think kind of, Spence, I definitely agree that if communication could be improved by just folks agreeing to send emails, that would be the best and simplest solution. But that's not happening currently. And so I don't think that we can request that and expect it to happen. And so, you know, when I think about information sharing, I'm thinking what I just listed, including any risk and need assessments that were conducted, right? So, you know, the LSCMI does require that there be a reassessment periodically. So if that's been done, if that hasn't been done, any violations that have occurred, any appearances before the court, any new court orders, obviously any contact with police. So really, I think, you know, when I'm thinking, and this, I'm with everybody in this boat. I am not a software developer, so I don't know how much of this we can get between folks. But really, what I'm thinking is that it would be a portal where there would be information sharing, in that KDOC and community corrections cannot actually alter anything within Tyler Supervision or Odyssey, and vice versa. So there is no capability of updating it. It would simply be just to pull information out. And there's definitely ability, because I know I've, you know, done this, I've seen this in other software systems, not Athena, not Odyssey, not Tyler, but in other software systems, where you can limit based on your login what you are able to see, so that you aren't able to go in and look at every single court record ever produced or something along those lines. So there can definitely be parameters that are built in. Something else to consider, I know because it came up in other committees, Spence, I think you're talking specifically to those committees, and Secretary Zamuda as well, that you know, while this rollout phase is happening, this is actually probably the best time to do this. Spence, I know you guys have a lot of data stuff going on. And you know, I know piling one more thing on top of that it would make me overwhelmed. But I think we're actually at an advantage almost that Odyssey and Tyler haven't fully rolled out to the state, because it is in a small number of districts right now. This is a great opportunity to work out the kinks before it rolls out to the full state. So if there is you know, some ability to do that, you know, I think Athena was rolled out statewide and we had some bumps along the way, right? But those are working out. So this might be a really great opportunity, unfortunately, to sacrifice those couple of districts that may have had Odyssey and Tyler rolled out, but to have them kind of pilot what that might look like. So that's another thought. And then I'll wrap up my comments and open it back up with, if it's an issue for KDOC, for OJA, to look at modifications and kind of look at the price tag, because I know OJA, you have so much going on, and KDOC, I know that, you know, further modifications with Athena is probably going to come with a price tag. We do have money from the sub award. The project that we are working through the Sentencing Commission now, and that Secretary Zamuda will actually be reaching out to you to speak with about it, would probably take up less than 200,000. So we have another $300,000 available there. So we could alleviate some of that upfront cost. Of course, that won't negate the continuing cost of management and if there's an issue between databases through the web portals, but we could alleviate some of that upfront cost possibly. So I'll pause there because I said a lot, but open that back up.
So if I could jump in right now, and I know nothing about contracts that brought the different software packages into being used, but I'm going to speculate that if Odyssey and Tyler are being rolled out now, there are probably contracts that will exist for years, and I don't think it'll be possible to roll back. I'm going to speculate it's not possible to roll back those, but might it be possible to select one that everybody will have access to, and that will basically be the go-to web base, even if say Athena is not the primary one used by a particular group. And I'm just picking Athena just for the sake of it, if Athena is one that maybe would permit different levels of permissions of access, then that could just be the one that in any dual supervision situation, the information gets loaded onto Athena and everybody just understands that that's going to be the common place for it to be on. But I'm guessing, and folks who know better than I do, I'm guessing that it won't be possible to walk back contracts with Tyler or with Odyssey as they're being rolled out.
Yeah, Professor Francis, I shouldn't speak for OJA or KDOC here. I don't necessarily think we need to walk back any contracts, or that the state needs to consider it. Usually with software contracts, you can make modifications or additions. So basically you add on to the contract. So it'd be something similar to an addendum that required another type of funding assistance, or everybody to go back in and say, yes, we want to pursue this in addition to what's already in place. So definitely wouldn't need to require a walk back at all, but more so just a modification. I think, with what OJA and the Sentencing Commission are discussing, that certainly would be the case, as more of a modification than a whole new contract, perhaps, or a walk back of an existing contract. But Spence, I may be misspeaking on that.
I would say you're fairly correct.
Okay.
Just the question is, what is that cost? I mean, I know you're saying that, there's a possibility of that, but if it comes back at $300,000 to make this work, that's a no-go. It's just not going to happen. And I would assume the same for DOC, depending on cost. So this is a big question, right? On how we data share. But if it goes to the legislature and we say that there should be a data sharing system created or a portal, but no money is given with that, it's unrealistic that this could even happen. And I know for OJA, you're also going to have buy-in by the Supreme Court. That's, they're the ultimate deciders that, DOC should be granted this information. So it's hard for me right now to say, this is probably possible, because there are a lot of pieces in play.
Absolutely.
For the
Stephanie,
OJA piece anyway.
Stephanie, this is Sheriff Carr. I think this goes back to the meeting yesterday. So we're back to a communication with OJA. Correct me if I'm wrong, folks, but I believe OJA is the ones who funded the current rollout through Tyler. So obviously there's going to have to be some communication with them for the court system.
Yeah, Sheriff Carr, that would be correct. Spence, I definitely hear you. And here's what I'm thinking is that we don't have to recommend something that is finalized, right? I think we can have layers to our recommendations. And so I think there's a way that we can start off even more simple than software changes. And that would be recommendations for standards of communication between community corrections and court services in the district. So, one of the things that I asked pretty much everyone was do you meet regularly with your counterparts, monthly, quarterly, whatever the case may be? And the resounding answer was no, that they don't. That the officers that handle dual supervision cases, so whether that be court service officers, community corrections officers, they do not meet with their counterparts to discuss where their cases are, how people are doing on their cases. There's no chance there for in-person discussion of what fines and fees aren't being paid that would prolong their supervision periods, things like that. And so I think even if this committee discussed kind of standards that they would like to see community corrections and court services meet when it comes to communication, I think that would go a long way and would buy the state some time to look into some of these more complicated and nuanced software kind of mechanisms where folks could actually start looking up the information themselves and relieve some of that time burden that every single supervision officer, regardless of where you're working, needs in their week. And so, you know, perhaps it's that if we have cases that are, you know, on 6-month probation, you know, the dual supervision period is pretty limited. It could be monthly. If it's usually a year or more, it could be quarterly. But getting them into the same room to discuss what's going on with cases, for court services to voice, you know, concerns that fines and fees have not been paid, and that's going to prolong their supervision, allowing community corrections to express that to the client that says, if you don't take care of this, you're going to stay on supervision with court services, something along those lines. But creating even more simple communication standards, I think, may go a really long way. And that's something that this committee could pursue, of just a recommendation that the districts get together with their supervision counterparts in whatever time frame you guys think appropriate. And by all means, that could include parole, of course. You know, definitely sounded like parole dual supervision is a less of a concern across the state. But it can definitely include parole in that, and parole could provide an update of folks that they're supervising in the district. So that's something to consider as well.
So I like that idea. I think it makes more sense, rather than us go into the weeds on the details of the communication, to address questions of, you know, setting standards, and not even that we set the standards, but that the agencies get together and set standards for what these communications will be like in terms of frequency and what will be discussed. And so again, I want to toss it out to folks who are from those agencies. What do you think is the best way for this committee to go about making a recommendation? Should we be more general in terms of just saying, you know, there have to be some standards that are put together, or should we give some details on the guidance on what those standards should be?
I think this is a hope. Spence and Shelley and Secretary Zamuda here.
This is Hope Cooper with KDOC. I'm trying not to take over any meeting and just state just my opinion, but I think the more that we can give guidance, the better off it's going to be. I think that certainly we mean well, but just as been said, it's not currently happening now. And I would request respectfully to add parole into those conversations, because I tend to disagree that parole dual supervision isn't an issue. I think it's probably the biggest issue, because we don't know who's on dual supervision. That's my opinion.
Hope, this is Stephanie with CSG. I'm really happy to hear you say that. I really like that idea, and I think you hit on exactly what I was thinking as well. As though, even though the districts are reporting that the dual supervision with parole isn't a concern, they were also reporting that it's not a concern because they actually don't have much communication with parole, and so there may just be some lack of understanding about who's on what supervision and what's taking place. So I think that's a fantastic idea.
This Sheriff Carr, it's kind of kind of off key, but on key. So we had an incident just the other night. Some of my guys dealt with an individual who's on probation. Ran him, got cut loose, no big deal. Probation officer calls out, I believe Monday morning, a little irate because we didn't arrest the individual because there was an A&D issue. So, I mean, so there's a lot of lack of communication. You know, we brought up the point that, look, you knew there was an A&D, there's a means for you to enter them into the system. So when dispatch would have run them, we would have known there was an order to arrest and detain, and we didn't. So, I mean, there's several areas here that are cross-contamination, I guess, per se. So it affects all of us. You know, we're fortunate here in our district. Parole actually has an officer in the community corrections building, but yet I still don't think they talk. And they're an arm length away from each other. So on the law enforcement side, we're just kind of sitting out here hoping that communications has an updated sheet of a list of people on probation. So
I think that this is Shelley from Manhattan. I think that the agreements between the entities, if they need to be specific, they need to start very basic. Given the state of all of our databases and the ability to share currently, I think it needs to be as simple as we need to be sharing caseload reports monthly with each other. That only addresses the local, you know, your judicial district, and I'm not thinking big enough, and I understand that, but in some bigger fashion, there needs to be a way that we can very basically compare who is on whose caseload across the state.
Spence, what are your thoughts on really what I'm hearing from Hope and Shelley is being a little bit more directive on information sharing and providing some perhaps more directed guidance on what should be shared and when or how.
Right. So some of the notes that I've made to myself here as we talk, taking into account what Hope has said and what kind of recommendations this committee can make. And this is just, I'm totally open to whatever, but this is what I wrote down, is that maybe a recommendation is a DOC, which would include community corrections and parole, obviously, and OGA create standards for communication, which would include, and however often it is fine, but I wrote down progress reports, violation reports, incentives and sanctions, and that's based off of what you said, Stephanie. And I think I'm missing something else, but maybe that we in the standards that we include all that information is what DOC and OJA should look at. So it's a little more pointed as to exactly what we want, what type of information, but I think if we can create some of those, make those recommendations, and then when the groups get together, then we can really focus on how that should look. If it's a monthly progress reports that we do, you know, or if it's only when there's a violation, or by, you know, every other month reports. I'm just trying to think how that recommendation could come from this committee. So I don't know if that answers your question, Stephanie, but that's kind of the way I was going off of what people have said.
Yeah, Spence, this is Stephanie with CSG. Yeah, I think that captures really well what I was describing. Sheriff Carr, I am not the best to respond to your comment. And so I would actually love if Spence or Shelley or Hope could jump in there with that. And how you guys see the best way to ensure that that information is being logged for PD or the sheriff's departments. to ensure that that's not getting skipped, I guess. I honestly don't know.
So
Shelley
part of my
did on-
thinking. Oh, I'm
Go
sorry.
ahead,
Go
Spence.
ahead, Sheriff. No, I'll let you
No,
talk
no.
first, Sheriff.
No, I was going off what Shelley said a while ago. I mean, we're in a technology world today.
Yeah.
I mean, look at it, right here. I mean, most everything we're dealing with web based. So, and I mean, I have softwares that I can allow access to the county attorney, to whoever I deem to view, as you put it, Stephanie. So you can limit your users' abilities. I mean, they can copy, they can print, they can just view. I mean, so we're looking at just a platform. You know, I'm fortunate not every agency in the state of Kansas has MDTs, mobile data terminals. So, I mean, the guys, we're training our guys currently on the use of them, and to cut down on time dispatch. You know, if it's not an urgent need, my guys have a tool at their disposal. They need to use it rather than picking up the phone and calling dispatch, or the radio and calling dispatch, or calling probation and parole. I mean, so if we have a means to get into this platform and just look it up, okay, they're on paper, here's their probation officer, then we can just contact them. And then as we're talking here, so if there are violations that are arrest and detain, or maybe an actual warrant, then it's there. We've got it at our fingertips, and you know, we go about our way. And but yet again, even when we do arrest somebody on a probation or parole violation or a warrant, we do contact those officers that are tasked with checking on them. So
This is Hope Cooper. Oh, sorry, Shelley, go ahead.
We share that we have a monthly meeting with our local law enforcement. And so we share whatever arrest and detains or warrants that we have updated in the past month. But again, it's informal and
Yeah.
local.
So I'm going to suggest that we hold this conversation together, and I think a way to do that might be to pick up on what Spence had said, which is basically just in our recommendation, make a recommendation that DOC and OJA create standards for exchanging information about progress reports, incentives and sanctions, violation reports, and whatever other issues you, the experts, think need to be exchanged. And also, in addition to that, create a mechanism for sharing this information with law enforcement. It may turn out that the standard will be extending access permissions to other people to your own databases. It may turn out that the standard may be, you know, monthly meetings, quarterly meetings, but I think it may not, that might be too much detail for this group to get into, but I do think that if our recommendation should be that the stakeholders go ahead and create the standards for exchanging information.
Professor, this is Jeff Samuda with KDOC. So maybe keep it fairly broad, but shall I include at a minimum the following? Something like that.
I like that. I think that's a good way of doing it.
I hate to do this, Sheriff Carr. I'd noticed we have Senator Haley on here. Curious to see what his thoughts are so far.
There it is.
Senator Haley, I don't know if you caught that last part. Sheriff Carr was asking if you had any particular thoughts about this recommendation that we're talking about.
None in particular. By the way, I'm pleased to see him a part of this deliberation, Sheriff, very much so. What I do is to try and vet what comes through the stakeholders, and it's more than an idle dialogue for me, because as those who are the stakeholders, Professor, that bring this through, when we reach to the point of looking at the committees, the subcommittee's recommendations, and of course the full committee's recommendations, I want to see the stream of deliberation that has come from this dialogue. So I guess that I defer to those who work with and who implement these policies every day to bring about the better solutions. And then I want to carry the ball, if you will, when the product is that comes through the committee is presented.
Thank you, Senator. Stephanie, do you think we have enough detail on this point to make a recommendation about information sharing?
Yeah, I really like where this is going. I think Spence's point and what he said was great. I really like Secretary Zamuda add there of that more specific, at minimum should include type of language. And then I think from there, it would really be beneficial for the state to go into the next recommendation of KDOC and OJA investigating or looking into what it would take for more efficient data sharing through software communication. That's not a great way to say that. That's off the top of my head. But through creating those portals, as Secretary Zamuda said, for information sharing, I think that next level of recommendation definitely gives the state direction to keep moving forward in, and is definitely something administrative that the legislature can see, but then OJA and KDOC can really move at their own pace, which may be a bit more efficient than the legislature, unless of course funding is needed. And so I think that's important too, because that'll allow OJA and KDOC to come together to get cost estimates for what that would take, and for the Chief Justice to review those and keep moving.
Thank you, Stephanie. So let's move on to the next recommendation that we should take up. And Stephanie, what do you think is the next point?
I think that the next point really around after information sharing is probably, and I say this because I think it came up the most with the focus groups, but is probably not easy to tackle. So I would be happy to kind of defer to the group here. But the difference in supervision approaches. You know, one of the biggest things that we heard was a difficulty amongst dual supervision cases is that community corrections uses different approaches than court services does. And that, you know, for instance, in community corrections, there may be opportunities for someone who messes up, that they get a sanction, but it's not quite as severe as what maybe court services would have given them for that sanction. That, you know, that violation needs to take place maybe 2 to 3 times before they see something more severe like court services would do. It's really difficult to solve some of these dual supervision issues when really different approaches to supervision are taken. So that's not an easy one to tackle, but is probably the next biggest one that we've heard through focus groups and through the other subcommittees as well.
So Stephanie,
Sorry,
sorry.
real quick. I think something to delineate here is the difference between pre and post conviction for an identification point here.
Yeah, Sheriff Carr, that's a great point. Definitely when we were talking through with supervision chiefs and directors, most of that conversation happened around post-conviction supervision.
I think it probably makes sense for us to focus more on post-conviction. But now as I'm saying that, how frequently would there be dual supervision in pre-conviction, in pretrial supervision? I suppose it could come up, but how commonly does that occur?
This is Hope Cooper with KDOC. I would just state that I think that the problem is we don't know. I would say that it's probably more likely to occur or be unknown, I guess, with parole, somebody on parole getting new charges and being on bond supervision and just the entities not knowing. But I that is strictly a guess. I do not know.
Stephanie, just for a point of clarification, have we totally thrown out the possibility of working on any kind of mutual agreement for the courtesy supervision, if you will, of duly supervised cases? Is that completely, I know I missed the last meeting and I apologize for that.
No, I don't think that's out the window at all, Shelley. I think that's a great topic as well, and one that we could definitely tackle here. As I said at the beginning of the hour, part of the difficulty that we're encountering is that dual supervision is being handled informally in so many places that it's causing confusion or it's causing this kind of inconsistency. And so, Shelley, I think that's a great point of tackling what does a mutual agreement look like? Should it be required across the board? And what should be included in those agreements? That's a great point, Shelley.
And so using the framework from your memo a couple of weeks ago, we don't have a lot of time left, I don't think today, or maybe we do. But we come back with recommendations on how we as individual committee members think that that could be realized as far as the recommendations.
By that, Shelley, this is Stephanie with CSG. By that, do you mean that because we are running short on time, which you're correct, I think we were only scheduled an hour and we have 13 minutes left, that apart members of the subcommittee think about what they would like to see included in those agreements, and then we come back together and we firm up that and enter that as a recommendation of kind of a template of agreement, so what's included and who's signing it and things like that. Yeah, I think that's great, Shelley.
That's what I meant, but you said it so much more eloquently. Thank you.
No. Just thinking through it myself. I think that's a great suggestion.
So a question I have with this is the mechanics. Are we talking about recommending statewide that agencies enter into courtesy agreements? Because I'm a little concerned that we might not be in a better position than we're in now. And I'd like to take this beyond just courtesy agreements and have it something that's more systemic. And Shelley, maybe what I misunderstood, maybe what you were saying is draw from what are used as courtesy agreements now and extract the best parts of those and have that as the framework for hopefully a uniformity in agreements statewide.
What is the difference? And this is just me actually asking the question because I do not know the answer. Is Where is the difference between a formal MOU that has to be signed and a courtesy agreement? Are they used in different ways across the state with different entities? I'm not sure if anybody knows the answer to that.
What's your sheriff card? I know I have some with other counties, and I mean they're basically the same. It's
Right.
I mean, you get down to legal interpretations with legal counsel basically on any of them. So, you know, what's binding and what's not.
Yeah,
And
that's what I'm
anytime-
wondering is the level of review the different language would require. Spence,
Yeah.
do you have any thoughts?
Oh, I was just gonna say, I don't believe, you know, and I could be wrong, but I haven't heard of any districts that actually have MOUs regarding
Okay.
courtesy supervision. I think courtesy
Okay.
supervision is just something officers do, kind of like interstate compact, you know, you just transfer that case to another individual. But I have not personally heard of MOUs between agencies.
Okay. That's great. That's helpful.
And this is Spence again, and I'm sorry, I haven't been stating my name. But the other thing, and I just wanted to go back to this, I think we really need to focus on post conviction and don't look at courtesy or courtesy supervisions or whatever transfers of bond, because those are a totally different type of supervision. You're not putting people through programming. You're not, you know, it might be simply they're coming in for a drug test, and it's not actually a supervision like we're all used to. So my suggestion was that we only focus on post conviction.
This is John. And Spence, I think that makes sense. And to a point, I think, you know, pre-trial supervision may have been something that was taken up by the Pretrial Justice Commission anyway. I don't know if they actually did address that, but I would assume that was something that they covered.
Yeah, and I think that's still an ongoing on what pretrial looks like.
So if I understood, one of the things that Shelley was suggesting is maybe folks send in the aspects of the agreements that you're currently using, the best or most useful aspects, and let's compile those. And I guess that's something that we can do by email. Just keep in mind that these will be open records, or these would probably be subject to open records if we're sending them to everybody. We're talking about committee business, so draft it with an eye towards that and preserve it with an eye towards that.
Professor Francis, this is Natalie Nelson from Legislative Research. I just wanted to jump in, and when you're talking about those emails, the best way to do that is to just send one email to one person. So maybe that would be you, and then, or you could send out an email and then BCC everybody, so that you don't have that serial communication, which is the issue with the open meetings requirements. So if there's a way that everyone maybe could send their thoughts to you, and then so that not everybody on the subcommittee is sort of emailing back and forth amongst each other. That's just a suggestion I would say.
Yeah, that's perfect. I am more than happy to follow your guidance on this. I don't want us to get in trouble with the open records. So yeah, if folks want to send their suggestions to me, and then I assume there would be no problem if I shared those with Stephanie.
Yeah, that shouldn't be a problem.
Okay, in the 8 minutes that we have left, let's try and take up one more issue. And so, Stephanie, what else do you think is appropriate for us to try to address today?
I would actually open that up to the group for Shelley and Spence and Hope, and ask. I know Hope parole hasn't been as big a part of the discussion as maybe it should have. But I would definitely open up to the three of you and ask where you see, the most need for further recommendations to be made.
This is Spence. Did we settle? This is just a follow-up question. Did we settle on who exactly is a supervision entity? Did we say the longest period, the longest sentence? Was that what we came up with or decided to do?
This is John. My recollection is that we did say the longest sentence would control, and part of the policy underlying that is that typically the longest sentence has the greatest need for programming, and so that was a good metric. Or you know, I think we said the most serious sentence probably is the longest sentence, but I think we said the most serious sentence.
Is
Did
part
you
of
have,
our
yeah.
is part of our recommendation then, like we've already decided, you know, that we say DOC and OJA create standards. It is part of that to make recommendations that the longest or most severe sentence is the controlling agency, and I use controlling agency simply as the supervision entity. That we just add that, or what's best?
Yeah, I think Spence, that's a great point. I think that was a couple of meetings ago now, and I remember there also being conversations though around the fact that if somebody received if somebody was on community corrections, let's say, and received something from court services, that they would remain with community corrections for the continuity of the case, and because of that relationship building process. So I don't know if we necessarily finished out that conversation, if my memory serves me correctly.
So this is John. Stephanie, you're right. I think we had talked about, you know, who would initially get supervision, but you're right. There was this question of if the more serious sentence ended first, would they retain supervision? And I think there were competing interests that were expressed. One was continuity of supervision, that relationships are built, shifting supervisors might not be good for the person, but there was also an observation that over supervising somebody with a more intense level of supervision may not be good for success either if that higher level of supervision is not really called for. And so I think you're right, we had not resolved that issue within that.
Yeah, definitely. This is Stephanie with CSG. And I think the other, to build on that, Professor Francis, I think the other issue too was that many times, not all the time, but many of the times that we talk to supervision staff, when a case did transfer back over into court services, let's say, the only remaining obligation was fines and fees, and community corrections has no authority to collect that on behalf of court services. And so, you know, if that's going to be the case, then there might be conversations there around if the only remaining obligation is something related to, you know, a condition that only one agency can enforce, that might be something to consider. We might be getting into the weeds a little bit here, but.
This is Spence. I'd like to just clarify a little bit on that, because all fines and fees that are collected by court services are those that are ordered by the court. We don't have any specific fees. So community corrections also does that with their orders, right? So when a judge orders, you know, probation fees or restitution or whatnot, corrections is currently collecting that, and there'd be no difference between that and what court services does. The payments simply go to the district court, which would be what any individual would be paying. So specifically for fines, I think the only difference really is, I know a lot of community corrections charge their own supervision fees, so that would be the only separate issue. And again, since all of the orders are court orders, and hopefully as Shelley's committee on conditions of probation make some headway. You know, those supervision orders might even be easier to follow. But I think, you know, overall, the standards should be the same between agencies on what can be supervised, since those do come directly from the court.
I would agree, Spence. I wasn't really sure where that came from, that we weren't able to collect fines and fees for court services, because we have our people pay at the courthouse anyway. So they could pay whether it be on a court services case or on a community corrections case. It might have come up in dialogues or focus groups wherein it could have been where maybe court services can't collect the supervision fees that community corrections charges, but that would be as simple as connecting them with that office, you know, to send a money order or walk them over there for a payment or something. I don't think it's going to be as big of a hiccup as maybe we initially thought.
This is Sheriff Carr. So I think if I recall, some of the concerns was program fees specifically, because community corrections has programs that they implement and there's fees attached to them. And I don't think there's any a set pay, or I don't know the terminology they want to put, but I think each independent region sets their own fees, their rates for a program. So I think that's the clarification point on this, because those fees go to the community corrections, not to the court.
But Sheriff Carr, when the legislature fully funds us, it won't be an issue. We won't have to charge supervision fees to make up for the programming that we provide. Just a little plug.
There's our comic.
Shelley, we'll get that in the recommendation section.
So this is John. I think the issue of, you know, who can collect fees, that is relevant. But what I'm thinking is kind of back to the original question of, if we've got somebody whose community correction sentence has expired, they still have court services supervision, but the only part that really is ongoing is collection of fines and fees. I guess the question is, should they still remain on this higher level of supervision that maybe community corrections would have, or does it make sense to scale them back to a lower level? And I'm wondering if we can just build in some flexibility by saying, you know, that if one of the sentences expires before the other, the organizations shall consult on, you know, how the public interest would be best served in determining which one will continue supervision, rather than us making that decision here, not knowing, you know, the different permutations that could come up. If maybe it makes sense for the supervising agencies to get together and make that decision based upon the facts in front of them. Kind of an interest of justice, public interest type of approach.
Steve String.
Spence and Shelley, what are your thoughts on that?
Spence, go ahead.
I think I killed the conversation when I made that suggestion.
It was really deep and it's at the end of the meeting, so maybe.
Yeah, I don't know, John.
Can we mark this? Spence is speechless.
Yeah.
Well, maybe what might benefit then is if we pause on that one and think through that one a little bit more. One question I did have is if we were going to meet again before the end of the month, and when that might be.
This is John, and that was the next thing I wanted to take up. I think, you know, we had been on a schedule of Mondays at noontime. We didn't this Monday because of the holiday, but are folks available on Monday, October 25th at noontime. And I realize that's kind of pushing us down to the wire, but I do think we need another meeting before the end of the month. We have the commission meeting next Monday, and so I'm thinking that Monday the 25th might work.
John, I would just pipe in and say, since our committee report is due by the 1st, and likely as we've determined, you'll be the one writing up that, does that give you enough time to put it together, to send it out to all of us, to make any additions or edits? And simply because of that, and again, I do, I've got 14 more meetings the rest of this week still, so I don't need more meetings. However, thinking maybe if we could meet next week, that might be better, just to allow you more time to put together a report to share with all of us, so that we can maybe discuss that and get it a final copy to the commission.
Yeah, no, I think that's a good point. I probably wouldn't have enough time to put it together and then circulate it for edits, and so yeah, I think that would be a little bit too much of a tight time frame. So yeah, Spence, I think you're right. Next week makes more sense. One option would be Monday the 18th, just before the commission meeting. Another option would be Wednesday, a week from today, so Wednesday at noontime. What are people's preferences?
I'll type in here. I'm not short of opinions on this. Wednesday at noon would work best for me.
This is Jeff Samuda. Wednesday at noon would work best for me.
Sheriff Carr, I'm good with it.
Same.
Okay. Then let's go ahead and plan on Wednesday, October 20th at noontime. And Stephanie, between now and then, you and I should probably talk on the phone.
Definitely.
Okay. All right, folks, we are over time. Thank you for hanging in there past the end of our scheduled time. We will come back together a week from today at noontime. Thank you.
Thanks,
Thank
everyone.
you. Bye, everybody.
Thank you.
Yeah.